Welcome to The Explainer. Let's be honest, the American legal system, it can feel like this huge, intimidating maze of rules and procedures. But what if you could actually understand how it all works? From a simple accident all the way to a final verdict. Let's break it down. So here's what we're going to do. We're going to make sense of it all by following one single lawsuit through these 5 stages, from the basic rules of the game right into the courtroom itself. Okay, let's dive right in. You might not think about it this way, but law, it's literally everywhere. Government regulations touch pretty much every single business activity you can imagine, from who you hire and fire to how you market and finance your company. And look, this isn't just about, avoiding getting sued. It's about building the critical thinking skills you need to handle complex situations and make the right call. The specific laws might change over time, but that ability to analyze a legal problem, that's a skill that will last a lifetime. I mean, just think about the real-world stakes here. Take Facebook, right? Way back in the beginning, it had to pay a staggering $65 million to settle just one lawsuit, a lawsuit claiming it had stolen the whole idea for its platform. A seemingly small legal mistake at the start can turn into a massive multi-million-dollar problem later on. Okay, so you've got all these rules, but where do they actually come from? To figure that out, we need to open up the legal rulebook for the United States and look at the 4 fundamental sources of law. So, American law is built on these 4 main pillars. But here's the key thing. They're not all equal. There's a pecking order, a hierarchy, that creates a really clear structure for how rules are made and how they're applied. Right at the very top, the king of the hill is constitutional law. The U.S. Constitution is the absolute bedrock for every other law in the country. If any law, doesn't matter where it comes from, violates the Constitution, it can be challenged in court and thrown out. It is the ultimate authority, period. Then you've got what probably comes to mind when you think of the law. That's statutory law. We're talking about legislation passed by elected officials. This covers everything from huge federal statutes passed by Congress that apply to all 50 states, all the way down to local ordinances that dictate things like building codes and zoning laws in your town. And then there's this huge area, administrative law. These are the rules made by government agencies, the FTC, the FDA, the EPA. These agencies have massive power to regulate entire industries, and they affect just about every part of doing business. And finally, we have case law. This is judge-made law, which we inherited from the English common law tradition. And this tradition had a really clever 2-part system for justice. If someone wronged you, you could seek a remedy at law, which usually meant getting money. But what if money couldn't fix it? Then you could seek a remedy in equity, which could force someone to actually do something or stop doing something. And that basic idea still shapes our courts today. So, what holds all this judge-made law together? It's this really important principle called stare decisis. It's Latin for to stand on decided cases. And it's basically a rule that says judges have to follow the precedents set in earlier similar cases. It's the glue that makes our legal system consistent and predictable, instead of just random. Okay, so we've got the rule book down. Now, let's see how it all plays out in the real world. We're going to follow a hypothetical civil lawsuit right from the very beginning, the case of Kirby versus Carvello. You can really think of any lawsuit as a journey with a pretty clear roadmap. It starts with some kind of incident, then moves to official court filings, then there's a deep dive to gather evidence, and only then, if it hasn't been settled, does it actually end up in a trial. So, let's follow our case down this path. So, let's get into the specifics of our case. The plaintiff is Jill Kirby from New York. She's suing the defendant, Antonio Carvello, who's from New Jersey. She's asking for $500,000 in damages because, she claims, he ran a red light in New York City, crashed into her car, and caused her serious injuries and made her lose work. All right, so to kick things off, Kirby's lawyer files a document called a complaint. This is what officially starts the lawsuit. It lays out why the court has jurisdiction, gives the basic facts, and says what she wants, in this case, money. And this line right here, that Carvello is negligent, that's the absolute heart of her case. Now, you can't just sue someone in secret, right? He has to be officially notified, and that happens through a procedure called service of process. A copy of the complaint and a summons to appear in court are delivered to him, and he has to take it seriously. If he just ignored it, the court could issue a default judgment, and Kirby could win without him even showing up. All right, so the lawsuit is officially underway, and this is where the action moves from the public record into what's often the longest, most important phase of the whole process: discovery. This is the pre-trial phase where, a lot of the time, cases are actually won or lost. Think of discovery as this massive intelligence gathering operation where both sides try to figure out what the other one has. They use all these tools to avoid surprises later at trial. They can take depositions, which is sworn testimony outside of court. They can send written questions called interrogatories. And of course, they can request documents. And in today's world, a huge part of this is e-discovery, digging through emails, text messages, all kinds of electronic data. And here's the thing that a lot of people miss. Discovery isn't really about finding that one aha, gotcha moment. The real point is to give both sides full access to all the relevant info. By getting all the cards on the table, it shows everyone the strengths and weaknesses of their case. This makes a trial way more predictable. And that's exactly why so many cases settle before they ever see the inside of a courtroom. But what happens if the case doesn't settle? Well, then the whole dispute moves to its grand finale, the trial. This is where the arguments finally get made in public. The evidence gets presented, and a decision is reached. And once you're in that courtroom, something really important changes: the standard of proof. In a civil case like Kirby's, her lawyer doesn't have to prove her case beyond a reasonable doubt. That's for criminal trials. No, here she just has to meet the preponderance of the evidence standard. All that means is she has to convince the jury that her version of the story is more likely to be true than not. It's a much lower bar to clear. You can almost think of the trial itself as a kind of play, unfolding in a really structured way. It starts with opening statements where each lawyer lays out their story. Then you get to the main event, examining witnesses. And finally, the lawyers get one last chance to persuade the jury in their closing arguments, right before the jury goes off to make its final decision. And this whole process, this whole back and forth, it's all built on what's known as the adversarial system. It's not some neutral investigation. It's a fight. The core idea is that the truth is most likely to bubble up to the surface when you have two passionate advocates for opposing sides going head-to-head, each trying to present their case in the absolute best light. And that really leaves us with a big question, doesn't it? The whole theory is that truth emerges when these two opposing arguments clash. But when you have two really skilled lawyers, each telling their client's most convincing story, does the battle always lead to the objective truth? Or does it sometimes just lead to whoever told the better story?